Transportation Committee meeting. Said the first things first, we're going to get done pretty quick. We discussed early on at our very first meeting road naming and dedication rules. You have a copy of them there, the same copy that you had seen before. I'll ask for a motion to approve those road naming and dedication rules.
So moved.
Have a motion by Senator Miller and second by Senator Dugan. All in favor, please signify by raising your right hand. Passes unanimously. Said you'll also notice there's a procedure in the packet, and I want to thank, I believe Jenna did that for us. Said one of the things that for me, we only have one senator, and he's a freshman that has followed all the rules. So we're going to take his resolution up first. So Senator Dixon said, please tell us about your resolution to honor our esteemed Charlotte Nash.
You don't have a sub
Yes,
165.
looking at renaming the intersection at Harmon Road and 316 after former Chairman Charlotte Nash. It seems very fitting to, that intersection is just within a few miles of a large family farm. It's a lot smaller today than what it was a few generations ago, but her family's lived out there for generations, so it seems very fitting to name that intersection after her. And she dedicated her entire career, to Gwinnett County, working as a staffer, up to the administrator, and then served as chairwoman for a little over 10 years.
Well, Senator Dixon, I can tell you, I served with Miss Nash. I was a city manager. She was a county administrator back in the day. Said and she did a lot of great things for Gwinnett, and I applaud you for bringing this forward. One of the things that, is there any discussion or concerns over the dedication? Is there a motion?
Motion.
Do
pass.
We have a motion do pass by Senator Miller. Is there a second?
Be a part of it.
Have a motion to pass, by Jason Anavarte. Said, I'm going to get there at this sooner or later on this, Jason. Said thank y'all. All in favor, please signify by raising your right hand. Senator C. Said you wrote. You did not vote. Okay, I understand. Said anybody opposed? We count that as unanimous, less one. And I'm not sure if Senator C. We'll just say you weren't in the room at that point, because you're not really. We're not sure. Okay, you want to. Okay. That was Senate Resolution 102 by the excuse me, not 102, 39. Senate Resolution 39 by. So you voting in favor? Thank you, Senator. So it's unanimous. Senator Gooch.
Yes, sir.
Happy birthday.
Thank you so much.
Said I think you are microphone number 15.
Yeah.
I think we're going to give you the floor for a little bit, and you can talk to us about whichever one of them bills you want to.
Well, let's start with the easy one first. Let me see which one's going to be the easiest. I'm waiting on a sub for 165. I was told you had it on autonomous vehicles. Let's go to 203, SB 203. You should have a committee sub in your folder on it. Am I correct?
We have a substitute LC 392942S, if that's what you're looking for.
All right, so this is a sub to the bill that we originally put in, dealing with seat belts in vehicles and the evidence being admissible in courtroom in civil trials.
Yes, sir.
So we did. We had a trial run in judiciary yesterday, and it failed 5-4. The trial lawyers don't like it. We've seen this bill in the Senate 2 or 3 times in the past, and we'd like for it to be heard on the floor of the Senate again this year. We have a new Senate, and it's a new term, and we think it's important that jurors hear the facts in a case. And when someone breaks the law and they don't wear their seatbelt, we believe that the jury should know that. We're not asking to tilt the scales in favor of either side. We just feel like before a jury decides on a verdict and awarding damages, they need to know all the details to the situation. There's a lot of scenarios. Both sides of the argument always have good, passionate arguments about how things happen, and they have examples of how one wreck occurred versus another. But at the end of the day, we believe the facts and the truth should be laid out on the table. This is the only evidence that is not permissible in a courtroom. I was told by one of the lawyers a couple of days ago that hearsay wasn't admissible, but I don't consider hearsay evidence. But when a professional and a police officer determines that someone was not wearing their seatbelt and they were ejected from a car, and the injuries could have been much less had they had their seatbelt on, I think that should be considered in the outcome of that trial. And this could impact any of us, our families, our business lives, whatever, on either side. So this doesn't favor one side or the other. I think it's straight up the middle. It's a fair opportunity for the truth to be told, and let the juries decide on the outcome of the case. So be happy to talk more if you'd like, but I believe there's some people that are here to speak for it. The business community, the Truckers Association is here. I see Ed Crowell in the back. There's no hidden agendas in this legislation whatsoever, so I'm happy to take questions.
Yeah, well, Senator Gooch, I'll start off with your first question, and I'll maybe pose to Ms. Dole. Do we have on line 51, it spells out off-road vehicles. Is there a definition in state law on what an off-road vehicle is?
Let me explain that. That's a rewrite from page 2 on line 25, 26. So we're just moving that language out of section 2, paragraph A, over to line 10. So we're not adding new language, we're just relocating it in the code section.
What is the bill number again?
LC 392942S.
Bill number is SB 203.
Gotcha. Where it says mounted upon. What?
It's not the
SB
first
203.
bill. It's not on the first. It's not on the first issue on the agenda. It's the second bill.
But Senator
No
Gooch,
hitting agenda, but it's just not on the agenda.
It is.
it is on the agenda. It's a substitute.
Okay, all right.
It's a substitute. to-
Read
Now we're
read
getting
the top.
So,
Read the top.
okay. it was-
That's what that is
it
on the end.
bamboozle, it was just a boozle.
Yes, sir. Said but Senator Gooch, when you say that it's on there,
All right.
If you recall, this language was in our bill last year, the omnibus bill that came to the floor and never got a vote, but it was tabled and never was taken off of the table. But this was one of the components of that bill last year.
I recall the bill well.
I'm satisfied that the members here have. Now, you got a couple freshmen that weren't here last year.
Ms.
so-
Dole, is off-road,
I'm fighting for you little men. Hey, I'm with you, baby.
do we need to define it in this bill?
Is this a vote or a hearing?
It's a vote.
This is a vote.
Yes, sir.
We got to get it the rules. Then we
The,
can talk.
one moment, please.
You're correct, we are just moving it, so it's not.
You've heard that before.
Say that a little bit louder for me, Ms. Dole. I'm going to have to get the hyenas out.
So you'll see that, he's correct, you're just moving it from line 25 to 28, it's stricken. And they're putting it down in 51 through 53 as new language, although it's still already within that code section. So it's not creating any new responsibilities, but it is not defined in the entire title. It's only defined in a different chapter with off-road. And I'm happy to read it to you if you want to define it.
But it is in code section 40. Off-road is in code section.
It's in chapter 7, right here in this bill, we're in chapter 8, so it's not technically defined. Chapter-
Do we need to do that?
It's always preferable to define it.
Well, so if we just take that language out, restore the original language, we still haven't defined it, right?
That's right.
So in
That's
current
what
law,
I'm
it's
getting
not.
at.
So my point is, we're not changing anything in that section.
Okay.
I didn't choose to put it there. I don't know if you did that as corrective language or if that was for another reason, but, so,
You can always say off-road, if you really wanted to, off-road vehicles as defined in 40-7-3.
If-
And then it's the same as.
right.
We'll call for that, as if you can write that for me, we'll
We
do
want
it.
to continue to exempt those vehicles from the seatbelt laws that are currently in existence.
That's correct. But I'm just thinking that,
So
that
we
if
didn't
we're,
move that.
if
That's
there's an accident and a vehicle was off of the road, somebody might claim it's an off-road vehicle.
That's right.
So I'm just trying to make sure we get it perfected. So you have somebody to speak, Senator Gooch, on behalf of the bill. Are there questions? Did I see somebody's hand up for a question? Senator C, you had a question?
Well, actually, I did not have the bill, and I was trying to get your attention so I could have it and follow through.
Oh, I apologize.
But thanks to my seatmate here, he's taking care of me, Mr. Chairman.
He's a great leader. I understand there, Senator Dugan.
She's worth every bit of it.
You know, just surrounded by guys, right?
Did you have somebody to speak on behalf of the bill, Senator Gooch? Because I don't have a sign-up sheet. Anybody signing in?
I think Mr. Crowell's in the back.
Okay, here we go. Here's our sign-up sheet. Ed Crowell, if you don't mind coming up from the Georgia Motor Trucking Association, glad to hear you. If you would, come up to the podium up here, and I'm going to turn your mic on over there.
Thank you, Mr. Chairman, Senators. On behalf of the Georgia Motor Trucking Association, I would love to ask you to support this bill. First, let me tell you just a little about the association. We are composed primarily of about 1,000 trucking companies and trucking industry companies here in the state, the vast majority of which are small business operations. More than 70% of our members are family-owned businesses that operate 20 or fewer trucks on the road, not big trucking companies that plaintiffs' lawyers like to put on billboards and tell you about. These are people trying hard to make a living, trying hard to employ people, and trying hard to operate safely. One of the problems they have in this state are frivolous lawsuits. One of the many contributors to frivolous lawsuits is an uneven playing field when they walk into a courtroom. One of the things that can't be done in the court is to talk about whether or not the plaintiff suing bears any responsibility for the injuries they suffered because they failed to wear the seatbelt, because they failed to follow state law. It's an oddity. As we've heard before, if a motorcyclist fails to wear a helmet, that can come into court, and the jury can hear the facts and say, well, that motorcyclist wasn't wearing the helmet, they should bear a little more responsibility for whatever injuries they suffered. Now, plaintiffs' lawyers will tell you that that prejudices the jury. Giving evidence to a jury does not prejudice a jury. If it's in question, attorneys can question that. They can argue back and forth and let the jury decide if it's factual. Not presenting evidence prejudices a jury. Not giving them the whole story creates prejudice. That's especially important to a trucking industry because attorneys and plaintiffs soon find, attorneys know and plaintiffs soon find out from their attorneys that even the smallest trucking company is required by law to carry very large amounts of insurance. And so we're constantly being sued, whether we caused the accident or not. I have a trucking company that just this week told me about a lawsuit where their truck was not even involved, but something bounced off their truck, and that was enough for an attorney to try to bring them into the case. They are going to have a terrible time defending themselves. The hope is that they'll just settle. The hope from the plaintiff is they'll just settle, that their insurance company will write a check and not argue too much. We need a level playing field. This law exists in about 30 states. It used to exist in more. It changes glacially because plaintiffs' attorneys put up such a fight against changing it, even though it's such apparent common sense that it should be a fair decision, a fair discussion of the facts. But it has been changing, and it's been changing to people allowing it into court. So I'd ask you to support this bill and then further support it when it gets to the floor. Thank you very much, Mr. Chairman. Be glad to answer any questions, but I want to be mindful of your time.
Thank you, Ed. Are there any questions for Mr. Crowell? Well, Senator C.
Senator?
I hate to have my back to you, but my
No, that's-
question is, you're mostly talking about rigs, your bigger trucks?
We represent everything from straight trucks all the way up to the tractor trailers.
Okay.
So it's just about everybody. But if it's a commercial vehicle, it gets that same problem of having to carry extra insurance and having the plaintiff's lawyers know that.
Okay.
Thank you, Mr. Crowell. Any other questions? Okay, Leader Dugan, you have a question
you.
for the esteemed bill sponsor. the birthday boy.
I do, just so, I'm sure it was
Esteemed.
covered in multiple forms yesterday and your other deliberations. With the motorcycles, I can tell you if he didn't have a helmet, because there is no helmet. How do you prove to 100% certainty they weren't wearing a seatbelt?
Well, I wish you'd have heard the testimony from Dr. Watson in the committee. He's on the Judiciary Committee, and he says as an ER doctor and a medical doctor, it's pretty obvious if someone has a seatbelt on. If they're in a crash with injuries, serious injuries, they're going to have contusions, they're going to have marks on their shoulders, or they're not going to have them. If they're thrown out of the vehicle, it's obvious that they're not wearing them most of the time. There's also professionals that can testify that they had their seatbelt on or off because of the EDR box. It's like the black box. In any car made since 2003, these vehicles have a black box in them. And you can download the chip. A mechanic can even plug a chip into the car and download to see if the seatbelt is connected, and it diagnoses other parts of the car, just like a state trooper. When they go out to a fatality, they recreate the scene, and they do a lot of this research. And so I'm sure a plaintiff's attorney or a defense attorney will hire an expert witness to come into court, and they're qualified as experts, and they'll testify either for or against whatever they're trying to argue. Same thing goes with whether the person was wearing a seatbelt, if it's not obvious. And you'll hear the other side argue that sometimes a person will get out of the car and to go render aid, and once they're out of the car, before the police or before the fire truck gets there, the ambulance gets there, no one really knows if they were wearing a seatbelt or not, and that's true. But that's why you have testimony. That's why people are sworn into a courtroom. They're under oath. And if they're found to be perjury, then there's consequences for that as well. But it's not 100%, but it's better than nothing. The goal is to try to get the facts out onto the table. It's not 100%, it never will be, but it's better than what we have today.
Thank you, Senator Gooch. Thank you, Leader. Senator Lucas, I believe you have your hand up, so we'll.
Why is it necessary to tell whether they had the seatbelt on? If a tractor trailer hit me, I don't have my seatbelt on, but he was in the wrong, why does it matter?
I think there's the legal side of it. Just depends on who you ask, Senator. But a lot of it comes down to awards. A lot of it comes down to just pure and simple money and who is responsible. Sometimes it's more than one party, and they call it the apportionment phase of the case, and they decide how much blame is allocated. There may not be 100% blame on one side. It may be 70% blame of the person who is driving the vehicle, but 30% of the blame could be placed on the person in the other vehicle if it's a vehicle accident. But if you're thrown from a vehicle because you're not wearing a seatbelt and you have major head injuries, you may not have been ejected from that car had you had your seatbelt on. You may have had a broken arm. The awards from a jury could be totally different. It could be millions of dollars difference. And I think having the facts on the table can make a difference. Now, I'm not an attorney, that's obvious, and there's going to be a couple that follow our testimony here today that will argue their side of the case. And we're not in a courtroom, but if we were, then I think as a juror, having all the facts could be important. It may be relevant as to how you would decide the outcome of the award of that case.
So what you're saying is now that you're not wearing a seatbelt, you're gonna call it contributory negligence on the part of the person who's driving?
I think having the truth never hurts, and the transparency and having all the facts in a case, just like any other crime that is committed, is relevant in a courtroom. I think that's important to know as well. And 20 other states have this language or similar language. I can list out the names of those states. I believe there's 30 states in Georgia, or outside of Georgia, that are where we are today. We would like to join the 20 that are not.
Thank you. Said I'm going to try to move things along because we've got a couple other bills on the floor today. We have on Zoom Lee Mickus with Ford. Said Andrew, if you can pull him up. How are you today, Lee?
I'm doing great. Thank you, Mr. Chairman, for the opportunity to address the committee. Because I haven't presented before, to introduce myself, I'm a lawyer in Denver. I have a national practice in product liability that primarily involves vehicle manufacturers. I'm here today, as you indicated, have been asked by Ford Motor Company to speak and also by the American Tort Reform Association to encourage your support for Senate Bill 203. Because Senate Bill 203 restores common sense and trust in the jury system by allowing them to consider this critical and relevant evidence. Every day throughout Georgia, we trust the juries to listen to the evidence and allocate fault among tortfeasors and assess damages. There's no reason to hide the truth from these juries just because a seatbelt is involved. Mr. Chairman, the current statute was enacted in 1988, and a lot has changed since 1988 when this rule came in, barring seatbelt evidence, came into effect. At that point in time, less than 50%, more like 40% of people actually wore their seatbelts, and a lot of folks questioned the efficacy of seatbelts at preventing injury. But in the generation or more that has passed since that statute was originally enacted, a lot has changed. In Georgia, for the last several years, more than 95% of people wear their seatbelts on a regular basis. And the debate about effectiveness of seatbelts is over. To quote the Governor's Office of Highway Safety, they state that, quote, one of the leading causes of motor vehicle injuries and deaths is the failure to wear seatbelts. And they also noted that in 2015, 46% of all vehicle crash fatalities were attributed to non-restraint use, meaning people weren't wearing their seatbelts. And I'd like to ask the committee to think about that. You put those numbers together, that means that 5% of the people account for more than 40% of the fatalities. That's pretty telling about the effectiveness of seatbelts and how whether they're used or not makes a difference. There's also a change in policy. Georgia right now actively and at great expense promotes seatbelt usage among all of the motorists on the road through paid media campaigns like Click It or Ticket and local law enforcement programs like the Seatbelt Convincer. The current acceptance and benefits of seatbelt use simply can't be squared with Georgia's current statute that prohibits jurors from considering, for any reason and to any extent, seatbelt non-usage by people who are asking for money to compensate them for their injuries and their suffering. This is a real policy oddity that somebody can be pulled over and ticketed for not wearing a seatbelt, but then in a civil lawsuit, they can hide that fact and effectively not be held responsible for that decision. And Mr. Chair, as somebody who represents Ford Motor Company, I find it also worth noting that Georgia courts have interpreted the current statute to go so far as to even prohibit seatbelt evidence in product liability crashworthiness cases where someone is suing an auto manufacturer like Ford, claiming that they didn't do enough to design the vehicle with occupant protection systems, and yet they can hide the fact that they weren't using the primary occupant protection system provided with the vehicle, namely the seatbelt system.
Lee,
And
I
should
appreciate
note,
your testimony. I appreciate
Sorry,
your
Mr. Chairman?
I appreciate your testimony. I'm trying to move things along, so if you can wrap
Yes,
it
sir.
up.
I'd urge your support. I'd be happy to answer any questions.
Any questions for Mr. President?
Thank you for being here, and thank you for your testimony today. What is the seatbelt usage rate in Georgia?
According to the most recent statistics, which were from 2019, the National Highway Traffic Safety Administration reported it as 95.9%.
95.9% of the people riding in automobiles wear seatbelts in Georgia. Am I stating that correctly?
That's the.
And so you.
I'm sorry.
Thank you. And I wanted to make sure that I was stating that correctly. And the 46% no seatbelt. I don't quite get how those two numbers line up.
Sure. I might have been moving fast on that. So that statistic was the proportion of fatalities, meaning people that were killed in car crashes who were not wearing their seatbelts. So, and that was from 2015, where the belt usage rates were about the same. So my point is that the 4% of Georgia motorists who don't wear their seatbelts make up more than 40% of the people who are killed in car crashes. So I think that goes a long way to establish what the governor's Office of Highway Safety has indicated, that is that seatbelts are very important in determining the outcome, whether somebody's going to be seriously injured or killed in a crash.
Gotcha. So 46% of the people injured in a crash, killed in a crash, 46% of them were not wearing a seatbelt. Am I stating that correctly?
Correct, yes.
So almost half and half.
Almost half and half.
Almost half and half.
Even though.
So I think you disproved your point, but go ahead. So your odds are 50-50, basically. If you were not wearing a seatbelt or were wearing a seatbelt, you have a fatality of 46%. Is that correct?
I think so. I'm not quite sure I follow the question. My point is about the proportions, that there are very few people on the road that are not wearing their seatbelts, but when crashes occur, they are vastly overrepresented in the most severe outcome.
If I can put that in a different language, he's saying in Georgia about 95% or more people are wearing seatbelts. So there's 5% that ain't. They represent 46% of the deaths across the state. Said they as an easy way to put that. So they're only a small percentage, 5% of the population drive, and they account for almost half of the fatalities.
Thank you. Thank
Said
you for
they,
clearing that up.
and if I could, I'm going to move things along.
Well,
I'm going to call on.
Let me ask you one more thing.
Okay. Yes, sir, Mr. President.
Did he bring up the EDR? Or was that? No, I did. You did? So
I was about to.
Okay. Can we get him to talk about the EDR for a minute?
Everybody knows what an EDR is. That's electronic record, man.
He's cross-examining.
Yeah, I'm worried.
I'm just trying to get the facts.
Go ahead, Mr. President. I'm trying to move us along because we got another committee meeting coming up.
What's the fact?
So the EDR gives us what information?
It'll indicate belt usage by position. Going back to the previous witness was absolutely right. Going back to 2003, it's been required, and even before that, most manufacturers had within the EDR or the restraints control module a channel that records whether the seatbelt for the front seat passengers, and now more and more other positions as well, were being used. In addition, there are other indicators on the vehicle. The belt itself is usually marked if the crash is of any significant severity.
Gotcha.
And there's other hardware that's typically marked.
Okay. So we're talking about acceleration, braking, speed. What other factors are we talking about on the EDR?
For the EDR?
Yeah, airbag deployment, obviously.
Oh yeah, I mean there's a whole host of things, and there are what they call delta V, the speed change in several different directions, longitudinal, vertical, side to side. Brake pedal position is usually recorded. Accelerator pedal is usually recorded. There are a number of channels.
Mr. Mickus, I think we got Perry Mason over here. Said but thank you for your testimony.
Matlock,
switch.
not Perry Mason, Matlock.
I'm going to switch things up just a little bit. I'm going to call on Dan Snipes from the Georgia Trial Lawyers Association. Dan, if you would step up here to the podium, and if you can, keep it brief. We got some things to move on, so we want to give you a fair shot at what's going on with our friends in the Trial Lawyers Association.
If y'all could have come to Judiciary Committee last night on Senate Bill 155, you could have heard the same testimony.
We can watch that on the video.
Yes, sir. So as most of you are aware, the seatbelt bill came to the Florida Senate in 2019 and was defeated. It was part of Senate Bill 415 last year that made it to the floor and did not pass. And then, like I mentioned last night, Senate Bill 155 did not pass out of Judiciary Committee. So this is the fourth time this bill has been heard in the last 3 years in the Georgia Senate. To start out, the reason Georgia trial lawyers opposes this legislation primarily is it attempts to shift the blame from the at-fault party to a collision to the victim of the collision. And the testimony about the Ford cases and about tractor-trailer cases deal with cases that involve catastrophic injuries. The majority of collisions in Georgia, far and away the majority of collisions, are smaller collisions that do not involve a loss of life or a permanent disability, thank God. And in those cases, that's where this statute will be applied 99% of the time in regular Georgians who are injured in collisions. And in those cases, it allows insurers to shift the blame from the at-fault party to the person who was injured. As to evidence, there is a multitude of evidence in Georgia, things that Senator Gooch says he just wants everybody to hear everything about the collision. Well, there's a multitude of things jurors don't hear because the prejudicial effect of the evidence outweighs the probative value. Those things include, who does the investigating police officer determine was at fault in an automobile collision? Jurors do not get to hear that one party received a citation for running a stop sign or failure to yield to the right of way, whatever the case may be. Jurors don't hear that. Jurors do not hear about insurance that's available to cover the cost. Jurors believe that the defendant who caused the collision, he's the person on the verdict form, not an insurance company. Let me see. I'm in a kind of a rush when I got up there, so let me just catch up to my notes. In products cases against Ford, jurors don't learn about prior revisions to the product to make it safer. So if Ford comes in and lowers the height of the Explorer, and Mr. Mickus and I had cases about Explorer rollovers, when Ford went in and made the vehicle lower and wider to make it safer, jurors didn't get to hear about these subsequent remedial measures where Ford was trying to make the vehicle do what my expert said it needed to be done, because that's too prejudicial. So there's a lot of evidence, like seat belts, that our policy is that it's too prejudicial. And in this case, the prejudice is that it shifts the blame from the at-fault party to the victim. Talking about EDRs, something that President Miller mentioned a number of times. Electronic data recorders have been around since 2003 roughly, but the generations change constantly. And in order to access that information you have to buy a program to download that information. That's the reason why the State Patrol Specialized Collision Reconstruction Team does that, but your troopers riding around on the road don't have access to that information. For the vast majority of car wrecks in Georgia, you would never be able to access this information because it's cost prohibitive. So you get into, what do witnesses say? Well, the first thing most of us do, if we're able to after a collision, is unbuckle and check on somebody. And by the time police get there, first responders get there, EMTs get there, you're not buckled. So then you get into a swearing match. And it's a swearing match that, once again, prejudices the injured party that did not cause the collision. At some point under this statute, you set up a scenario where someone could be killed as a result of a drunk driver, but because they weren't belted, the drunk driver would face no civil liability. One thing about this, and there's no one from the insurance company that will come before you and say this, there's nothing about this statute that will ever lower automobile liability premiums. Nothing about that. I will tell you it will not. And nobody's going to come in here and dispute me on that, because an insurance company will not tell you that that'll occur. I want to be respectful of your time. We did not know this bill was going to be presented today as a substitute. I was down the hall working on something else, rushed down here to present this, but I would like for you to remember this is the same legislation that the Senate has rejected in 2019, 2020, and last night judiciary. Thank you.
Thank you, Mr. Snipes. Said Dave, before you step away from the podium, said there may be a question, and I have one. Said I know, Georgia law spells out that if you're driving an automobile, you're riding in the front seat, you're required to have a seatbelt on. Said should we automatically assume that person has a seatbelt on? How do we deal with that in the court situation?
That's a great question, because if you look at the statute on seatbelts. In order to cite somebody, issue a traffic citation, and it's not a jailable offense, it's just a citation offense. In order to do that, the officer has to have a clear and unobstructed view of the person without the belt in order to even issue the citation. And that's not the standard that would apply under this civil admissibility. It would be a free-for-all based on, but it's not clear and unobstructed view, certainly. So that's a great question you asked, Senator.
Thank you. Said, are there any other questions for Senator Gooch? You have a question?
Yeah, and Dan, I'm sorry I didn't ask you this last night, but I wasn't on the committee. I wasn't able to ask questions.
I
And
wasn't testifying last
I've always
night.
been told a lawyer shouldn't ever ask a question unless he knows the answer, but I'm not a lawyer, so I'm gonna ask you. If I'm driving my car down the road and I have a 7 or 8 year old child in the vehicle and they're not restrained and I have an accident, would that be admissible in your cases that you're talking about?
In Georgia right now, the failure to buckle your child, if someone runs into you, we want to keep the focus on the person that caused the wreck and not on the failure of the parent. Has the parent done something they don't need to do there? Certainly. But the cause of the collision was the person that ran the stop sign. And very interesting, because that does bring back, as I rush through, on these tractor-trailer collisions,
Yeah.
when an 80,000-pound vehicle hits something at highway speed, and those nurses, Georgia Southern nurses on I-16, and they got hit from behind by an 80,000-pound vehicle traveling 55 miles an hour, seatbelts don't matter then. When a case I had last year, and a tractor trailer pulls out in front of a mother with her child buckled in the back seat, and it's a right under case, and she gets the top of her head ripped off, and she's belted, seatbelts don't matter then. Young man from Statesboro tragically killed in that collision back in December, seatbelt didn't matter then, because he was hit from behind by a tractor trailer. When tractor trailers run into people carrying a load, seatbelts don't save lives then. Distracted drivers take lives then.
Mr. Chairman, I'm not here to try to defend a truck driver that does wrong.
Well, I
But
just
I'm not
countering
gonna, I don't want to support or defend a drunk driver who fails to buckle his 8-year-old child up in the back seat either, or in the front seat, which he shouldn't be. And if that's not admissible in a courtroom, don't you think that had a little bit to do with the child being killed?
Senator Gooch, if the parent's the drunk driver, there's no case there. There's not a case there then. If the parent's the drunk driver and it's
Sure
his
about
child
that?
in his car, there's not a case there.
Even if the tractor and trailer drove through a red light and hit the drunk driver, they can't sue the trucking company and the insurance company?
The drunk driver, that comes in, that the driver's drunk. Yes, sir, it does. That's called contributory negligence,
Okay.
comparative negligence
But
in
the
Georgia.
seatbelt violation is not admissible.
Seatbelt violation would not, but but if the driver's drunk, I can tell you this, that's not gonna be much of a case.
Thank you, Mr. Snipes. Said the Senator Anna Batarte.
Butch wants to ask about something.
The button don't show up over here. You got to wave at me.
Kind of missed it because you were talking fast, and we're not in a court of law right now. So could you go back and talk about what in terms of this bill related to DUI situations in your testimony earlier?
So if a
Just make sure we got you right.
I want to understand, if I understand Senator Gooch's question, a tractor trailer hits a vehicle, the
Right.
driver of the vehicle's DUI, okay? And there's a child that's unbuckled, not in a child safety seat in the vehicle. That's not a case, because the drunk driver in Georgia, if you try cases, you don't want your plaintiff to be a drunk driver. That's how you lose cases. That's not a good case.
Well, I mean, I'm familiar with the DUI laws because my brother was killed by a drunk driver. So all right, that's all I want to know. Thank you.
Thank you.
Thank you.
Senator Miller, you have a question. Mr. President.
I was just going to clarify for Senator Gooch when he said a 7 or 8 year old child in a car. If I could direct your attentions to line 83 of your bill.
Go ahead.
You'll find the answer to your question.
I wanted to
But
ask, I wanted
7-year-old is not, but an 8-year-old is.
to hear him answer it.
And if I answer without the benefit of having seen the substitute, I'll be,
But the answer is that it's not admissible. And I think if a parent fails to buckle their child, then there should be some blame allocated to that. Maybe the traffic light malfunctioned. We don't know. You're not going to recreate that scene because nobody was there except for the two vehicles. Both vehicles said they swear the light was green. They both came through the intersection. It's going to end up in a jury's hands. Having the information on the table, all the facts that are there would be helpful, including the EDR information. And you can get that off of a mechanic. I know of that. We heard that testimony as well yesterday. It's not just the state troopers that carry that block of that information.
Thank you, Senator Gooch.
It's proprietary data that you would have a license to obtain, and it is not inexpensive to be able to have the proprietary data to download EDR.
Well, a good
and
lawyer can get it, correct?
What's,
A good lawyer can get it.
and one who's willing to spend money can get it.
Correct.
Senator Gooch, because you have all three bills on the floor.
I'm ready.
You-
I'm not arguing.
You want to call this to a vote, or where do you want to go?
Sure. If
Okay.
there's
is
other
there
people
any-
want to testify.
The,
we
I
move
can,
on.
I can take that testimony, but we're eating into your other bill time, so.
Okay.
Which way you want to go? More testimony or take a vote?
Well, leave it up to the committee if they want to hear more.
Well, is there a motion to pass?
I'll make a motion, do pass.
We have a motion on do pass LC 392942S. Is there a second?
Second.
Is there a second? Said Senator Dixon, said any other concerns?
Parliamentary procedure, Mr. Chairman.
Yes, sir, Mr. President.
I'm going to vote, but I think that the members of the committee would have had an opportunity to review the substitute prior to arriving. Would have been beneficial for all concerned.
You're exactly right.
just wanna
So
make sure I'm on
we'll
record.
thrash the birthday boy later.
You'll have that opportunity in the next meeting in just a few minutes, so we'll use that.
Well, after I voted, it won't matter.
I understand.
The,
We see that a lot.
good point, Mr.
Do I
President.
want to play with poker with my
Said-
cards up or my cards down?
Depends on your
I'm
hand
playing with
is.
my cards up right now.
That's right.
We have a motion and a second. All in favor, please signify by raising your right hand. Let the records reflect. We have 1, 2, 3, 4, 5, 6, 4, and those opposed. We have 2 opposed, and Senator President Dugan. So we'll write you down as a no vote. Said so we have 2 opposed, and 1 abstaining. Thank y'all. Senator Gooch. Guess what? You have the floor again for another
Well, I hope
bill.
the next one will be a much easier discussion. SB 165, the original bill dealt with autonomous vehicles. The sub that you have is only going to deal with the strobe light on a slow-moving vehicle, which is basically an electric car. We have made this change at the request of the industry to allow the amber strobe to be in place on top of the vehicle, or current law, which requires the triangle emblem on the back. So this is a either or, but not a requirement for the strobe. The industry folks have said that there's other manufacturers that would come to Georgia and sell their vehicles, but they do not want the strobe on top. So this is a compromise with the House on that language. Simple as that.
Does anybody have a question for Senator Gooch? My only question to him, could you draw a slow-moving vehicle sign for us?
I can, but we'll talk about that later.
Thank you. Said do I have a motion to pass? The leader has moved, do pass. Is there a second? Senator Dixon has seconded. Said on LC 392937S. Said all in favor, please signify by raising your right hand. I'm looking, I see 1, 2, Senator C, are you voting? Okay, 1, 2, 3, 4, 5, 6, 7. Are you up or down, Bert? Senator Jones said, okay, and any opposed?
I'm gonna oppose Mr. Chairman. I'm just sick and tired of coming in here, getting changes and all. I mean, this is so rough. I'm uncomfortable with this, so no.
To help
Yes.
satisfy her concerns, ma'am, this language was in the original bill, but the other stuff in the bill was taken out. So you're not voting on anything that you haven't seen in this bill.
And I appreciate that vote, Senator C, and appreciate your comments. And One opposed. Said the motion passes.
Senate Resolution 102 is just an extension of the Georgia Commission on E-commerce and Freight Infrastructure. You all know that we've been working on this for 2 or 3 years now, and we need to continue to work with the House. We've spent several years on it. I think Senator Jones and Senator Miller, were you not on that Freight Commission? I was not. Okay, well, Senator Jones can tell you that we're making good progress, but the work's not over. We need to continue working to try to get freight moving through Georgia. I didn't hear you. Oh, you'll be on it. You're a good man. So that's it. That's simple.
Senator Gooch, I was asked earlier today, was those appointments that are made, are they to still, they could be carryovers, or that's up to the discretion of the appointing body, is it not?
I believe it would be up to the as you see in the language, lines 41 through the rest of that section, 41 through 58.
Okay, so can be a carryover, can be new members.
That's right.
Any other questions for Senator Gooch? Do I have a motion to do pass on LC 392848, Senate Resolution 102? Is there a second?
Second.
Senator Dixon, second. Said all in favor, please signify by raising your right hand. It's unanimous. I'm glad we all got together. Ladies and gentlemen, we stand adjourned, and I apologize to those folks that didn't get to testify on Senator Gooch's first bill. So.